Welcome to the Goldwater Institute's Dark Money Debate. I'm Bob Robb, editorial columnist for the Arizona Republic, and I will serve as your moderator tonight. I must say it's enjoyable to be part of a debate that will actually be a debate and not a joint appearance masquerading as a debate, as we usually find in political discussions and communications. The topic is anonymous political speech protected by the First Amendment? And as I say, we will have an actual debate. We will have opening statements. We will have rebuttals. Each side will be given an opportunity to try to trip up the other with a provocative question. I'll have a period of time to direct questions back and forth between each side. We will open up the floor to questions from you, and then we will have closing statements to finish out the debate. The Institute would appreciate it if you would fill out the survey. They're looking for before and after responses, what your feeling is about the topic as we enter into the debate, and what you feel about the topic as you exit from the debate. And if you want to protect the anonymity of your political speech, simply leave it on your chair, fold it over, and we'll try to make sure your prying neighbors don't play the NSA and try to peek at what your answers and responses are. As I said, tonight's topic is anonymous political speech protected by the First Amendment? To me, there's actually three subcomponents of this question, three other separate but interrelated questions. The first is whether under existing Supreme Court precedents is anonymous political speech protected by the First Amendment. The second is, did the framers intend for anonymous political speech to be protected by the First Amendment? And the third is, should anonymous political speech be protected, or should the targets of it have a right to know who is attempting to persuade them? Now, this is my framing of the topic. The debaters are free to join my family and most politicians in the state in completely ignoring what I have to say about the topic. But that, I think, you will see play itself out as we proceed with the debate. Let me introduce you to our debaters. For the affirmative and having home court advantage is Kurt Altman, who is senior attorney for the Goldwater Institute's Scharf Norton Center for Constitutional Litigation. Among other extensive legal experiences, he spent several years as an assistant U.S. attorney for the District of Arizona. Joining him on the affirmative team is Alan Dickerson, who is legal director of the Center for Competitive Politics, a national organization dedicated to promoting and defending First Amendment rights to free political speech, assembly, and petition. On the negative side is Daniel Barr, who's a partner with Perkins Coie. He is chief counsel of the First Amendment Coalition of Arizona, and he also has a bit of a home court advantage in that he's an adjunct professor at this particular institution, the Walter Cronkite School of Journalism and Mass Communication. Tom Irvin is currently with the ASU Alumni Law Group, and among other relevant legal experiences, he served for several years as special counsel to the Maricopa County Elections Department. So to begin the debate, the affirmative will have 10 minutes to make its case.
Thank you very much, sir. So the question is whether anonymous political speech is protected by the First Amendment. And when I first saw that question, it occurred to me that it was a deeply unfair question, in the sense that the answer is so painfully obvious. Of course, anonymous political speech is protected by the First Amendment. Enormous swaths of political speech are unambiguously and uncontroversially protected Newspaper editorials have been signed anonymously or pseudonymously since the beginning of the Republic, a fact that the Supreme Court recognized and approved as recently as 1995 in the case of McIntyre versus the Ohio Election Commission. Union canvassing in attempts to get people to join private sector unions have been an anonymous activity since at least the 40s. The ability to gather signatures for ballot measures has been protected under the Buckley versus American Constitutional Law Foundation case since 1999. Pamphleting by anonymous individuals, again, was approved as recently as 1995. And one need look no further than the existence of Twitter and the internet to realize that enormous amounts of political speech occur in this country on a daily basis, anonymously, and with the full protection and, in fact, acquiescence of both the Constitution and the American people. None of this has excited any particular controversy. But you could say, Mr. Dickerson, you're being willfully ignorant. You should look at the title. It says, dark money. Is there anonymous political speech that is protected? So let's turn to the question of money in political speech. As probably everyone in this room knows, the Federalist Papers were not, in fact, signed by the Founding Fathers. They were signed Publius. But this was not an unusual fact. Most of the debate surrounding the ratification of the Constitution was signed by other individuals, calling themselves things like a Pennsylvania farmer, or Cato, or other references to classical literature and history. It's always been understood that to have free speech, one must have free association. As the Supreme Court put it in NAACP versus Alabama at the height of the Civil Rights Movement, effective advocacy of both public and private points of view, particularly controversial ones, is undeniably enhanced by group association. And as the Buckley Court recognized in the 70s, in the midst of Watergate, at a nadir of public trust in government, effective communication in a mass society requires the expenditure of resources. It is simply not true or practical for language and messages and political argument to be done on street corners and through anonymous handbills. So here we come to the question of whether or not this should be done anonymously. In general, the court has said yes. In the Talley case, coming out of the, I believe it was the 70s, out of California, the court noted that it has consistently said that the danger is that identification and fear of reprisal might deter perfectly peaceful discussions of public matters of importance. This has always been true, not only of majority positions like those who were arguing in favor of the Constitution's ratification, which I might point out was in fact an election. This was done in New York. It wasn't just sort of a philosophical debate. There was an election for individuals who would serve in the ratifying convention from the state of New York. And this is neither here nor there, but those of you who are interested in this, it's been noted that the requirements for voting in that election were the lowest point in the English-speaking world. They'd gotten rid of property requirements. Every free male citizen of New York, and that's an unfortunate turn of phrase, but in the 1790s it meant something, was permitted to vote in that election. So against these values, against the question of how over time groups have consistently used the ability to be anonymous, this has been consistently protected, and it has been noted at times of particular unrest in particular, that the anonymity of the speech is an important part of its effectiveness and the protection of the speaker. We might ask against these values why we would want to say no. Given that the costs are so obviously high, that the dangers of the regulation of internet speech, the dangers of the inability to bind together into free associations without the prying eyes of the government and one's neighbors, what possible interest could be placed against that sufficient to override it? For after all, so much political money is already disclosed. Much of the terms of this debate are deeply unfair. At the federal level, every contribution to a candidate over $200 is disclosed on the internet, along with the address and in some cases the employer of the donor. All money given for express advocacy, any communication which says vote for or vote against this person, is disclosed over that same amount. Money given for ads that merely mention a candidate in close relation to an election, money given for those ads is disclosed. If you go to the FEC's website, you can pull reports that list all of this down to a very extremely granular level. Nor is it just the direct contributions. There are substantial laws on the books, as the Supreme Court recognized in the McCutcheon case last term, which prevent the funneling of money through organizations for other purposes. Giving money to one organization or a shell corporation or an LLC or any of the other creative horribles you hear about all the time for the use by another organization to elect a candidate is illegal. People go to jail for this. I have filed a number of briefs in cases where people have gone to jail for this. And they don't go to jail for short amounts of time. This is a serious criminal violation the Department of Justice will come to you for. And finally, in political advertisements, which is most of what this debate actually involves, it's not that it's anonymous. Organizations list their names on the front of the communication. So the real question is, what is left, given that enormous, almost universal disclosure regime that already exists under current law? Well, what exists is money that is given to a nonprofit, generally a 501c4, C5, C6, C13, we can get into this later, but money that is given to a nonprofit for general purposes, not earmarked money. The majority of that money cannot be used for politics, but some portion may, in the discretion of the receiving institution, inevitably or ultimately or at some point down the line that we can't really decide, be used for politics. That's what we call dark money. That attenuated link of causation from the donor through an independent organization that cannot spend most of its money on politics to an eventual ad which lists that organization on its face. And what do we get for this? If the point is to see who stands behind a candidate, to see who a candidate's constituency is, in the words of the Buckley Court, isn't this too far afield? In some states, the state of Delaware, I'll use this example because it comes up in one of my cases. In the state of Delaware, if you run a nonpartisan voter guide that lists every candidate for office and their positions on certain issues, as self-reported by those candidates, you list those candidates all equally for the education of the voter. You have made what is called an electioneering communication, and all of your donors over $20, going back 4 years, come into the public domain. If you're not bothered by the invasion of privacy that implies, what information is being gathered? Is it really plausible that someone who gave money 4 years ago to an organization which does very little of this type of speech was attempting to elect or defeat one of the numerous candidates listed on the face of that voter guide? It's simply not useful information. It's not actually providing anything to the electorate. This isn't directly contributions to candidates. This isn't money given to PACs. And that is perhaps why it is that support for quote-unquote disclosure collapses upon further analysis. And probably the leading study on this by Professor Dick Carpenter, he noted that when asked whether the government should require that the identities of those who contribute to ballot issue campaigns should be available to the public, 82% of people said yes. But when asked if their contribution should be made public, 56% said no. And when asked if their employer should be listed on any report, 71% said no. And your employer is listed in almost every state and at the federal level. Perhaps then you see that once this issue comes home, we are wiser than we expect and we foresee the difficulties. Because if we're honest, we know that greater disclosure means that fewer individuals will contribute to nonprofit organizations. In fact, there's reason to believe that that is the intention of people pushing for greater disclosure to these groups. And if we're honest, we know that with fewer contributions, there will be less speech. And there's reason to believe that those people who get really upset about negative attack ads, and look, I live in Virginia, a swing state. Believe me, I understand. People who are upset about that sort of speech, really they don't want to know who's paying for it. Really, they want to just see less of it. And finally, we need to ask whether we now live in a time where the costs of disclosure have gone up even since the period of the framing. In a world where this information is put online at very small dollar amounts and stays there forever, permanently, in a searchable format, people who give, under existing law, people who give to support candidates are making an essentially limitless bet on the future. They're saying that in the future, any employer, any romantic interest, any friend, any business contact with Google can figure out who I support in the 1980 election. And I think a lot of people, older than myself and at my level, might not be comfortable with that sort of a level of inquiry going forward. We see a lot of hard-fought issues that change over time. And we have to ask whether locking people into those positions forever is worth the cost, or whether what we'll really see is simply a collapse of civil society.
Thank you, and now we will have the opening statement for 10 minutes from the negative.
Thank you. First of all, I want to thank the Goldwater Institute for hosting this this evening. I mean, the Goldwater Institute has long fostered intelligent civil debate on important issues, which clearly stands in clearly stands in contrast to the shouting that you see on cable TV that passes for debate. The question this evening is whether anonymous political speech is protected by the First Amendment, and the short answer to that question is yes, but it's a qualified First Amendment right to anonymous speech. That right is balanced against other rights that may overcome that First Amendment right if private or governmental interests are sufficiently important to do so. Let me give you an example in the private context. As we know, there's a lot of anonymous speech on the internet. They're called gripe sites, or my favorite are the suck sites. There are also anonymous reviews on things like Yelp. And the courts have devised a test on how to deal with protecting anonymous speech in those circumstances. The Arizona Court of Appeals, in a case called Mobilisa versus Doe, a 2007 case, said to compel the identity of an anonymous speaker, the court will look at, one, whether the party requesting the disclosure has a viable cause of action that would survive a motion for summary judgment on all the other elements of the case that have nothing to do with identifying the speaker. And then second, the court will then balance the party's competing interests to see whether it favors disclosure. And let me give you two examples of when the court would order disclosure and when it wouldn't. If you had a libel case brought by, say, I don't know, Joe Arpaio, and against an anonymous person who called him a goofball on the website, and Joe Arpaio brought a libel suit, the court would not force disclosure of that person's name. Why? Well, first of all, Joe Arpaio is a public official and he has a high burden of proof. And second, calling him a goofball is not a factual statement, even though many of us would think so. That could survive a motion for summary judgment. So the court would not order disclosure of that person's name. However, switch the facts and have the libel suit brought by, say, a local restaurant owner against a person who posts anonymously on Yelp that the restaurant had failed several health inspections, and the only reason they had stayed in operation is the restaurant owner had bribed county health officials. Those would be defamatory statements. And in that instance, the court would order disclosure of the person's name in such a libel suit. The same type of balancing goes on in the public context of people participating in the political realm. The most recent U.S. Supreme Court case is Doe versus Reed, a 2010 case. In that case, a public records request had been made in Washington State for the signed petitions to put a referendum on the Washington State ballot to overturn a newly created Washington State law to expand the rights of state-registered domestic partners, which included same-sex domestic partners. The plaintiffs in that case brought an action to prevent the state of Washington from disclosing the names, saying, if you disclose these names, we're going to be harassed here, and we're going to be vilified and ridiculed, and we have a right to anonymous speech under the First Amendment. The case went up to the Supreme Court, and they brought two claims. First, that under the Washington Public Records Law, that was unconstitutional as applied to the compelled disclosure of referendum petitions in general. The second claim was that it was unconstitutional as applied to the disclosure of the petitions in this case. The Supreme Court, in an 8-1 decision, held that disclosure of the referendum petitions in general did not violate the First Amendment. Citing Citizens United, Justice Roberts said that disclosure requirements may burden the ability to speak, but they do not prevent anyone from speaking. The court went on and said that because there is a qualified First Amendment right to anonymous speech there, the court then applied what's called exacting scrutiny analysis to the public record statute. Under that analysis, the court looks at whether there's a substantial relation between the disclosure requirement and a sufficiently important governmental interest. The court also noted that it gives states wide latitude in implementing their voting systems. In Doe, the state of Washington asserted two governmental interests. First was preserving the integrity of the electoral process by combating fraud, detecting invalid signatures, and fostering transparency and accountability in government. And the second was providing information to the electorate about who was supporting a candidate or a ballot initiative. Justice Roberts held that the first interest, standing alone, upheld the constitutionality of the Washington Public Records Law and required disclosure of the referendum petitions. When the case then returned to the trial court in the Washington federal courts, they had a trial, they had a hearing on whether the statute as applied to these particular petitions was unconstitutional. And the plaintiffs had to show a reasonable probability that compelled disclosure of the fact that people signed the referendum petition would subject them to threats, harassments, or reprisals from either the government or from private parties. And the plaintiffs in that case had the opportunity to put on such evidence, and 19 people were deposed, all of whom had taken public stances in favor of the referendum, and all of whom had signed the referendum, many of whom had passed out referendum petitions. And this is what their proof was. Some say they were concerned about being harassed, but they hadn't been harassed. Others testified that they had received a few nasty phone calls. Another person testified that while he was collecting signatures for the petition at a grocery store, two ladies walked up at him and glared and said, "We have feelings too." Another person testified about 3 incidents. First, that he said a man had directed expletives at him and pushed him. The second incident, and this is my favorite, is that a man had mooned him while petition gatherers were standing on the corner. They had apparently driving by and mooned him from the van. Hopefully he wasn't driving. And the third was that a woman had approached him and said, "We'll do everything we can to stop you from doing what you're doing." That was their proof. So when asked to come forward and say, "Give us actual proof of how you were harassed," this was the proof. And the trial court noted that all of these people also testified that they thought police involvement in these incidents were unnecessary, or if they did call the police response was sufficient. And the trial court again went back to what the Supreme Court had said in the Doe case, first noting what Justice Sotomayor had said in concurrence, that when bringing an as-applied challenge to the statute fighting disclosure, it must require evidence of serious, widespread harassment that the state is unwilling to control. So 2 elements. You have to be harassed, and the state has to be unwilling to control it. And we have historical examples of that. Back in the early 60s, there was a case, NAACP versus Alabama, that went to the US Supreme Court, where the state of Alabama was trying to kick the NAACP out of Alabama. And what they did is they found out that the NAACP had failed to file certain business disclosure statements about doing business in the state. And so Alabama said to NAACP, "You're out of here." NAACP says, "You're right, we failed to do this, here, we're going to do it now." The state of Alabama went to the extent of getting a court order to prevent the NAACP from complying with the Alabama statute. They then wanted the NAACP to provide not only a list of its officers, which was required for the state disclosure, but we want a list of all of your members. And the NAACP said, "No. I mean, first of all, we're not required to produce that. And second of all, I mean, this is at the time in the late 50s where people were getting harassed and beaten up and some lynched for that activity." The Supreme Court held that that was evidence of actual harassment, and held that the NAACP didn't have to release the names of those people. Supreme Court also noted that there was no reason for the state of Alabama to have these names in the first place. So getting to the second question, I'm told to stop, but I just go a little further. Getting to the second question, did the framers intend for anonymous speech to get more than qualified First Amendment protection? And the answer is no. There's absolutely no evidence of that. Yes, Hamilton and Madison and John Jay wrote some of the Federalist Papers anonymously. And yes, there was a tradition of anonymous political speech at the time of the Revolution, but that doesn't prove that there's a First Amendment right. Indeed, Justice Scalia wrote 20 years ago in his dissent in the McIntyre case that, quote, to prove that anonymous electioneering was used frequently is not to establish a constitutional right. Evidence that anonymous electioneering was regarded as a constitutional right is sparse, and as far as I'm aware, the evidence was generally non-existent.
We'll wait till rebuttal to approach the third question. I'll interrupt the course of the debate to share a story with you. When I was in college, I debated a traveling team from Oxford, and the social scene at Occidental College was so pathetic. This was actually a relatively well-attended event. And the opening speaker for actually the rebuttal speaker for the Oxford Union was going on and ran past the time available, and the poor timekeeper, first of all held up a card like this and then held it a little higher, and he kept talking and talking and talking, and held it a little higher, and he kept talking and talking and talking, and then finally she stood up and he said, I know my time has expired, I just can't be bothered with stopping now. We won't be running this debate according to Oxford rules. 5-minute rebuttal by the affirmative. Kurt?
Or I could take it.
No, your choice. So if Alan, if you want to do it, go ahead.
So I guess there's the two questions. One is what the law is, and the other is what the law is intended to be. In terms of what the law is, the Doe versus Reed case is a very interesting case. Because it doesn't come up in the context of sort of what you usually think of as political speech, right? It's not ads, it's not people writing editorials, it's signature gathering for deciding whether or not a ballot initiative makes it on the ballot. So, I mean, what the court said was that, this is something of an unusual situation because it's the people exercising legislative power. The analogy isn't to, standard political speech. The analogy is to, can legislators take action in private? And then the answer to that is obvious. Of course not. I mean, you have to have an actual registered vote if there's going to be legislative action by the state assembly or the state senate. So I would suggest that Doe versus Reed is a little bit off point, respectfully. And I'm sure at some point we'll have a chance to argue this in front of an actual judge. But that leads to the second question, is this issue of whether anonymity is tied to a reasonable probability of threats, harassment, or reprisal. And I would suggest no, both legally and in terms of sort of aspirational principles. No legally, because the Talley case is very inconvenient for that point. I mean, the Talley case is one where California, the city of Los Angeles, had an ordinance that said if you put up any sort of flyer of any sort, and you have to put who did it on the front of it. And if you don't, you're guilty of a violation. This went to the Supreme Court. The Supreme Court said, no, that's crazy. I mean, of course you have a right to anonymously put out flyers. This has been true forever. And there's a dissent which says, well, I won't vote that way because they haven't presented any evidence of threats, harassment, or reprisal. If that's the basis of the dissent, it stands to reason the majority disagreed, and that the burden is on the state to justify its interest rather than on civil society to justify its need for privacy. And the other is sort of the aspirational point. Well, there's one other argument too, which is that in the on-point political speech debate, the Buckley versus Vallejo court wasn't asked these sort of questions. It was asked, the law that Buckley was reviewing came out of the Nixon scandals, out of Watergate, and it said, if you are an organization that takes money and spends it for the purpose of influencing a federal election, you are a PAC and you must tell us who all your donors are. And the Supreme Court said, that's nuts. They didn't even sign it. I mean, they just had a per curiam opinion, with like maybe one dissenter on this point, which said that's completely insane. What does it mean to influence an election? I have no idea what that means. Do you know what that means? I mean, they basically said that you can't have that as the governing standard. And facially, period, that can't be the rule for disclosure. If you want disclosure of the donors to an organization, you have to show that they are expressly advocating the election or defeat of a clearly identified candidate, and that's the reason they exist. It's not some small thing they're doing on the side, it's their major purpose. That's Buckley. So while recognizing the law is very much in flux, I would suggest it certainly has not developed fully in the direction that has been suggested. And finally, the aspirational point. It's very odd to think to yourself, well, can this particular group show that it's going to be subject to the threats, harassment, and reprisal? Well, maybe. I mean, sure, absolutely. The situation in Alabama in the 50s was horrendous. And I would never suggest that we're living in those times now. But that's not the question on our First Amendment analysis. The question is, will we ever live in those times again? And you're making this bet about, will there not be future debates that we can't envision? Will there not be new organizations that will be created? And that the provision of this information without a sufficiently important reason is simply going to be ammunition when those dark times do or do not return. And for those of us who take a very long view of the Constitution, that's a terrifying idea. I don't particularly want my children and my children's children bound by the $20 campaign contributions I make. I can't imagine under what theory of government that's necessary. So that's the other question, sort of, you know, which side of the predictive coin do we want to make our bet? Do we want to say that the disclosure of this sort of information is so important to the Republic that we're willing to risk that sort of a long-term bet? Or do we want to say, no, history teaches us, and certainly the founders would have appreciated this point, given their experience intellectually of the English Civil Wars and the Protestant Reformation and various other equally horrific events that were very bloody, that no, there is a role for civil society that is outside of the state. There is a role for the creation of associations, even new ones that respond to new issues that can't predict how popular they will or won't be. And that's why it's a fundamental right and not a contingent one.
Thank you. And the 5-minute rebuttal from the negative.
Thank you, Bob. The Citizens United case put together in one sentence the First Amendment and disclosure. And in that sentence, in a part of the opinion that was 7-2. Citizens United was 5-4, as everybody knows, but the disclosure portion of Citizens United was 7-2. And in that 7-2 vote of the US Supreme Court, the Justice Kennedy opinion said the First Amendment protects political speech, and disclosure permits citizens and shareholders to react to the speech of corporate entities in a proper way. This transparency enables the electorate to make informed decisions. I believe Citizens United would have come out different without disclosure. Section 4 of Citizens United was decided 7-2. Now, 5 months later, the Doe case was decided. And the Doe case is, as Dan described it, the referendum petitions in the state of Washington. And in the Doe case, Justice Scalia, in his concurrence, shows that he did not change from the 1995 McIntyre case, because the second point that Bob outlined in his 3 points was the framers. Where were the framers on this? And so in 1995, Justice Scalia said in the McIntyre case in his dissent, joined by Justice Rehnquist, Chief Justice Rehnquist, that the court discovers a hitherto unknown right to be unknown in that case. So the originalist on the Supreme Court says that the right for anonymity is a hitherto unknown right to be unknown. And then we come to the Doe case, where Justice Scalia, 5 months after Buckley, not Buckley, Citizens United, excuse me, says, this is Justice Anton Scalia, for my part, I do not look forward to a society which, thanks to the Supreme Court, campaigns anonymously. This does not resemble the home of the brave. That's how he ended his concurrence in an 8-1 decision that backed disclosure. So in 2010, in January, Citizens United is 7-2 that disclosure is constitutional. Anonymous speech is not a constitutional right. And 5 months later, that is underscored in Doe. That is the state of constitutional law today. So what should we have? So we have the framers did not think anonymous speech was a constitutional right. Justice Scalia in McIntyre and Doe goes through that history. He is the originalist. He goes through it, and it's not there. So on the aspirational point, Bob's third point, what should it be? Well, the surveys are building up that the massive amount of undisclosed money is resulting in a level of cynicism that is driving people away from the system. And that driving people away from the system is something we should all be afraid of. And it reminds me of a book I read, a number of books, but remember Kevin Phillips, the emerging Republican majority in 1969? Well, he's a demographer at heart. And about 12, 13 years ago, he wrote a book called Wealth and Democracy in America, which is a demographic book about who's been rich in America since the first boat got here. So it's interesting, a little dense, but interesting. But what he does is he goes through the 400 years, he looks at a cycle, and he ends up with a sine wave. And the sine wave is that upon occasion, like the robber baron era, the rich get piggy. And what happens then? Then we have a progressive era. And the progressive era bottoms out, and then we have another era where the rich ascend, then we have another progressive era. Over 400 years. He goes back to the tulips in the Netherlands. And it's a compelling history. And that level of cynicism and the people pulling away from political activity is something we should worry about, because there is no constitutional right for anonymity. And legislatures and the Congress can deal with this through statutes, and they should.
Thank you very much. We now go to the questions between the debaters. The affirmative side will have 1 minute to frame the question. The negative side will have 4 minutes to respond. You will not be punished if you do this more expeditiously than that.
So our question.
Our
question, right?
Yeah.
Thanks, Bob. We have a lot of questions that we could come up with, but one, what we're talking about here is disclosure of contributions, right? So take it that the negative side, my colleagues over here are demanding the current amount of disclosure or more. So how exactly can you demand the level of disclosure that you're looking for in this and preserve the long-standing tradition, we're at the Cronkite School here, long-standing tradition of anonymous editorials, anonymous publishing that is intended to affect the campaign. Editorials that are often much more effective than money. Newspapers that sanction a certain candidate. Newspapers, frankly, that are run typically by major corporations, publishing companies that are run by major corporations. And it's been a long-standing principle that anonymous editorial boards, newspapers endorse candidates, and candidates seek those endorsements. How do you square your demand for the disclosure that we're talking about with that?
I'll take a first crack at it, but I mean, if you're saying, like, for instance, the Arizona Republic's editorial board is anonymous as who wrote it, I mean, it's no mystery who those people are or that it's the paper writing it. And just also as a further editorial point, I would say in these days, the effectiveness of a newspaper editorial versus, I don't know, $10 million, there's not really much comparison between the two. So, I mean, as far as the long-standing tradition you talk about, the long-standing tradition is not as you portray it. The standing tradition is that we provide anonymous speech basically for people who are being harassed, who are being oppressed, people who are in the minority, people who have unpopular positions, and the like. To equate that to an unsigned editorial in the Arizona Republic or The Economist is nowhere near the same thing. We know who's writing those editorials. We know what the process is. In fact, I would say the process of newspaper editorials is as transparent as you could possibly see. You see the candidate being interviewed online. You see what the questions are. You know the people who are involved in it. And so that is precisely the type of transparency that we would be looking for as far as political contributions. You know, it's important to know, one of the things that's important to know in how we govern ourselves is, you know, who has power and how they're exercising that power. And to know who is giving large amounts of money for independent expenditures, which, let's face it, they do get funneled to particular candidates. I mean, I don't want to shock people there. I mean, that's an important thing to know. Not only who is doing it, but once you know who is doing it, you can start to figure out why and what they might expect for that amount of money. And that's important information for how we govern ourselves as a democracy. I don't know if I have any time left, but.
Do you want to amplify, Tom?
The only amplification is that in the McIntyre dissent, Justice Scalia and Chief Justice Rehnquist go through the history of newspapers, go through the history of anonymous pamphleteering, and say that that's just not speech that is designed to affect elections that would be covered. So tying the newspaper world and election regulation properly crafted, narrowly, is not an intellectually sound analysis because it has not been upheld. So when you have Justice Scalia and 8 of the Supreme Court justices saying disclosure is fine, that they've gone through that history, they've looked at that original intent from the 1791, it's not there. And the regulation of money is allowed and is constitutional, and newspapers are allowed too. They don't meet.
Thank you. And now the negative has a minute to frame a question for the affirmative, and the affirmative has 4 minutes to respond.
Our question will be, if there is a constitutional right concerning political speech being anonymous, why do you go back to the Talley case and the NAACP case, which predate Citizens United and Doe by decades and were discussed in Citizens United and Doe? Why don't you use the modern cases, and how do you explain an 8-1 and 7-2 Supreme Court on these issues?
I'll start. I think it's important to go back to that case, the NAACP case, because that is a perfect example, really, of the potential harm of eradicating anonymous speech. Certainly that's an extreme example, and an example that, as my colleague indicated, hopefully is unlikely for us to live through again. But it is the seminal case. It is the seminal example of the harm that can come from disclosure. There are many reasons people want to remain anonymous, but that is, as exhibited in the NAACP cases 58 years ago, that is the most extreme, the most dangerous, and really the most telling as to why anonymous speech in America is important. We want to foster the dialogue. We want to foster the message. We want it out there without a focus necessarily on the speaker. I think mandating that speech and the disclosure of the speaker in all cases really does a disservice to the public, and is looking at the electorate and the public in this situation and saying, you know, you're really not smart enough to understand the message. You need to know the speaker.
And I would just add, I mean, it's a question of the general versus the specific. I mean, when you go back to these cases, because they established the baseline principle that, you know, speech is more effective if done together, that the right to associate is an independent political right, protected independently by the First Amendment, and that the lifeblood of free association is money. That it's impossible to speak effectively in a mass society without the spending of money, full stop. And from that general principle comes the later campaign finance cases. And I mean, you guys know this history. Buckley comes along and says, if you want to intrude upon the right of association, you must do so narrowly. I think a lot of where we disagree is on the question of whether or not, in fact, as was stated in the rebuttal, you know, we are narrowly tailoring this to actual speech that affects campaigns. And I think that's why we look to the older cases. Because the later cases that say, if you take out an ad that says vote for or vote against someone, I don't think we disagree that that should be disclosed. But for instance, I represent a woman in Colorado who wrote a 30,000 word, she's a PhD in philosophy, she wrote a 30,000 word policy paper on abortion, the last sentence of which said, if you grade the previous 30,000 things with 200 footnotes to Aristotle and such, the only moral choice is to vote against this ballot initiative. And the state of Colorado wanted to regulate that as a political ad, a 30,000 word paper, and wanted to make her tiny little organization with $2,000 into a political committee. That's not narrowly tailored, and that's the problem.
I'll break from just saying, who on earth read to the end of that article to find that out?
I could introduce
Talking
you to
about
some
one of my
people.
columns, or
The 30,000 word one, yeah.
Apparently, Dan, the Colorado state government read to the end of the article, and that's the problem.
The download statistics figured prominently at the trial.
now it's my turn to ask some questions back and forth. Alan, you confused me with your last statements, which sounded like an enormous concession that I suspect you will want to reel back and create some kind of distinction on. What's at issue, what the public controversy is about ads about candidates during elections, the source of funding for which is at best obscure. Are you saying that governmental efforts to compel the disclosure of those ads is permitted under the First Amendment?
I'm not sure I said anything I didn't mean to say, in the sense that, yes, it is under certain circumstances, and those circumstances have been very carefully laid out. I mean, the problem is that when people say dark money, they don't mean these narrow categories. They mean that, because that stuff's already disclosed.
Well, no, there is a disclosure of such. The Good Government Committee is spending $25 million to say that candidate X is a liar and a cheat and shouldn't be elected. The Good Government Committee is a nonprofit, not required under federal law to disclose its donors. Does the state, in regulating campaign-related speech, have, under the First Amendment, the right to require the Good Government Committee to disclose its donors?
I mean, I would need to know more about the corporate structure of the Good Government Committee. Is the simple, I mean, here's my point. My point is that because we have decided that there's no right to anonymity, people don't care about these lines anymore. And because people have convinced themselves that some tiny amount of the money that's actually being spent in elections is being spent in the way that you just described, which may or may not be true. But because people have convinced themselves of that, we've started writing such enormously broad definitions that we're starting to sweep in speech that has nothing to do with elections. And I represent a lot of these people, and a lot of them are not 501c4s, they're 501c3s. They're groups that are prohibited by federal law from intervening in elections and do not, under federal definitions, intervene in elections. The states write these insanely broad laws. If you mention a candidate and you put it on the internet and it costs $100, you've just did something that affects, even if the legislature's in session, you've done something that is now campaign-related speech. The problem is that these words are losing their meaning.
Well, let's return to the campaign context and the Good Government Committee, which is spending millions of dollars in express advocacy about a candidate. Kurt, do you agree that the government has a First Amendment right to compel Good Government Committee to disclose its donors?
Well, I think the current status of the law is that the donors that provide money to the Good Government organization with the intent, purpose to advocate for the election or against the election of a certain candidate are disclosed. They currently are disclosed. There are laws that require that disclosure right now. So this debate about these organizations using their dark money, money where nobody knows where it's coming from, to affect elections, is really overblown. I think statistically, we were discussing this earlier, in 2012, the election that we all talk about that says, oh, it was after Citizens United, this dark money blew up, the presidential election, there were, 50 million times more money spent on that because of Citizens United. The reality is about 5% of directly campaign-related money was undisclosed. So the thought that dark money, there's no ability to find out where this money's coming from is what's driving these elections, just isn't accurate.
Tom, I want to ask you about the practical ability to force disclosure of anonymous speech groups that are spending money and express advocacy during an election on candidates. Given the core finding under Citizens United, the core finding under Citizens United was that corporations and labor unions have a First Amendment right to expend from their general treasuries on express advocacy. So given that that's the core finding, despite all the positive language in Citizens United about disclosure, how, as a practical matter, do you force it? When you have these nesting organizations, it doesn't matter where you choose to require the disclosure to occur. The pooling can occur in some kind of corporate entity the step before that. It can expend from its general treasury, and what is reported by the entity that is required to disclose is the contribution from the corporate entity from its general treasury. So even though Citizens United has positive language about disclosure, hasn't its core finding actually made disclosure impossible to compel?
Well, there's a couple of points. The first major point in response to your question, Bob, is that Citizens United, just on the point Bob was making in the question, is one of the most naive Supreme Court opinions in history because it assumes disclosure. It assumes it, but in never thinking that smart lawyers and other people with money would go out and use 501c4s and stack entities. But I think it has challenges, but it is not without the ability to get to that disclosure. Because you go back and say in a statute that the original contributor, the person, for example, the person who paid taxes on the money, the person who gave the money to the first nonprofit, which then gave it to the second nonprofit, that gave it to the third nonprofit, that gave it to the fourth nonprofit, that spent it. The person who paid money on that, it has to be disclosed. Well, how do you get to that? Well, you get to that exactly the same way agencies get to drug dealers who try to stack money through corporate entities to corporate entities. That's called money laundering. So you say it in a statute, and people will obey that statute for the most part. People who don't obey that statute, you go after them just like you go after money launderers, because that would be the law, that the original contributor would be disclosed.
But if a corporate general treasury can be a contributor,
yes,
why can't
absolutely.
it be the original contributor to the entity that is required to disclose? What gives you the right to penetrate and create restriction on that corporation's First Amendment right to expend money from its general treasury?
Well, there's under the concept that I'm describing, there is no restriction on the right to spend money. It's just disclosure. And disclosure is perfectly proper to order up, as the Supreme Court has said. So, for example, in your example, one of the things that is popping up in the literature, business literature, is that boards of publicly traded corporations and general counsels and CEOs are coming to grips with this all over. A significant number of the Fortune 500 big corporations have decided to disclose. Why? Because, as Citizens United said, shareholders need to know what they're doing. So major corporations are voting to disclose because they don't want to be in this position. So there's starting to be a momentum in the corporate world to disclose because the push is, give us some money secretly. Well, people don't want to do that.
Under your scenario, if the Chamber of Commerce, or the Sierra Club, expends from its general treasury monies on express advocacy, do they need to disclose and report their membership lists and the amount of contributions from each member?
An organization that has a broader purpose than influencing an election, like a Chamber of Commerce or other things, would have the exemptions that they have now. If it's only an election organization, then there would have to be a disclosure. But large membership organizations that spend money wouldn't have to disclose if the statute is written properly.
Now, Dan, you've described a typical judge-made balancing act as to when anonymous speech, even beyond the campaign, the candidate campaign context, is permitted, where you have a judge decide whether there's a realistic fear of reprisal and whether there is a compelling government interest that overpowers that in terms of disclosure. Is it really right or fair to leave those who want to participate in political debate uncertain as to whether they're going to have to disclose or not until some judge, some point down the line, engages in this balancing act? Or shouldn't we have brighter line rules so people can have confidence when they participate?
I think you just described what most of our legal system is in the application of any law. I mean, it's not, I mean, there are very few black and white principles in the application of laws. Here, I mean, the basic rub of what this debate is about is, you know, I would say there's a qualified First Amendment right, and if you're actually being harassed, you have the ability to do one of two things. One, get law enforcement involved, because there are statutes on the books to prevent people from being harassed, to prevent people from, you know, being threatened and all of that. And two, under the case law here, that you can come forward and make an as-applied challenge, and if it's the NAACP case or the Talley case or whatever, if you can make the sufficient factual showing, they will protect your anonymity. The same as the Arizona Court of Appeals does in the private context. What the affirmative side doesn't want to do, what the affirmative side doesn't want to do is say, we don't want to make that factual showing. And the reason they don't want to make the factual showing is often there aren't any facts. It's all sort of apocryphal information. And when you sort of drill down to it, you're left with people mooning people outside of windows and things like that. So I would say if there are real situations based on facts where people are actually getting harassed, the law will protect them. If it isn't based in fact, you'll lose. In fact, I mean, you can sort of break it down this way. If your argument is the following things could happen, you're probably going to lose that case. If you can show actual facts that have happened, then you'll probably win the case.
But why is that fair to political actors to have that uncertainty before they engage in political speech?
Because you're balancing the interest of their interest in anonymity here, and their interest is in anonymity is if my name is revealed, I will be harassed, I will be punished in some way. If you show factually that doesn't happen, their interest falls away, and you have balanced against that the state interest of knowing who these people are, so you can make whatever judgments you are about who's backing a particular candidate or resolution, and you can make whatever judgments you want based on that.
But you're going to ask a question, but I want to address that for a second.
I was going to ask you to address that for a second.
Perfect. That is a great question. That is a great question. I think I'll address what he just said for a second. But what he's talking about, and when you're asking about the bright line and this balancing test, and is it fair, is it right to have the political participant have to go through that, I think that's really important here and really important in this debate, because in essence, what we're doing with this is taking the common person, the woman who wants to start a petition or gather people and associate with people to fight against a bond issue in a city. What we're creating is a prior restraint, because that person, it's a prior restraint on her speech, because that person doesn't have the lawyers that the big money people that give to some of these organizations that you were talking about that are professionals at political speech have. She doesn't have the lawyers. She doesn't have the accountant. She can't navigate these laws. So what do they decide to do? They decide to not enter into the political arena.
Let's talk about the person who's the target of an attempt to persuade them to vote for or against a particular candidate. Why shouldn't that individual have a right to know who is trying to influence their vote? And let me amplify. We have laws to protect people from harming other people or threatening other people or intimidating other people. But if I don't like the political views that are being thrown at me by a particular corporation or a particular person, and I want to exercise my economic rights to boycott and not patronize that person, why isn't that a libertarian interest that the law should protect?
Well, I think to begin with, the person that is the target of this speech, which is what we're talking about here, they can address the message rather than the person. And I think the allowance...
No, but I can't boycott the person. I can't exercise my economic liberty to say I don't want to add to the largesse of the person whose views I find abhorrent and obnoxious in the way that they're presented to me.
Well, I think the current state of the law, again, which is a misconception, allows that target the knowledge of the corporation and the big money that's coming at them in this situation. Again, under the current system, these organizations that are put together in order to advocate... Did I just see a stop sign? I just started. We got a timekeeper problem.
I violated it earlier. Go ahead.
I'm the moderator. I can extend my question and answer.
Now I forget what I was saying. No, we have the current system that's in place does require that disclosure of contributors to those organizations that advocate for or against the election of an individual. You're talking about McDonald's. McDonald's provides money to some organization that advocates against your election. They provide the amount of money under the current federal system. The federal law requires that disclosure if the money's designed for that election. You're going to know who that person is under the current state of law, and I guess you can boycott McDonald's, which might be better for your health.
Let's open it up to questions from the audience, and I think we've got microphones that are coming. Is that correct? First hand up went right here.
How do you do?
And let me say, we're under Jeopardy rules. Your question has to be in the form of a question. Speechifying is left to the debaters.
In the interest of full disclosure, my name is Paul Avalar. I'm an attorney with the Institute for Justice. Among other things, I sue under the First Amendment to overturn onerous campaign finance laws, including recently Arizona's in a case called Galassini v. Fountain Hills. I have many questions and comments, but my one question, I guess, is directed at Mr. Irvin, and it's about Justice Scalia's position in both his dissent in McIntyre and also his concurrence in Doe v. Reed, where you seem to be very taken by his originalism. He said his originalism made him believe that there was no right to the anonymous ballot. That is, that in America we have what we consider to be the right to vote anonymously, but maybe we don't. If you take Justice Scalia at his word that we have no right to engage in anonymous political speech, do you also take him at his word that we have no right to the anonymous ballot?
Well, thank you, Paul. That's a good question. Justice Scalia points out in his dissent in McIntyre that until 1888, we didn't have anonymous ballots. People in the 1700s, the 1800s, up till 1888, they went to a town meeting, like a New England town hall, and they said, who's going to vote for Mr. Smith? Raise your hand. Who's going to vote for Mr. Jones? Raise your hand. And he goes into the long history of that and says, based on the framers, and based on the time of the 14th Amendment, so he goes in 1791, and then the 14th Amendment after the Civil War, and says there's no constitutional right to a secret ballot. Now, the United States went to the Australian ballot, and Justice Scalia goes into that. So the fact that something we consider to be obvious, that we should have secret ballots, is not a constitutional right should be no surprise, because not everything we hold dear is a constitutional right. So, and in the Galassini case, in which Paul did a tremendously good job, in that particular case shows the difficulty of election law. Because when a federal judge starts out an opinion, an order, and says, my job in this case is to determine whether a 187-word sentence is ambiguous. Well, what does that say? And that's the bad writing of statutes. So many examples that we find about this happened to that person, Mrs. Galassini, or this happened to that person, is because of terrible laws. And to go back to a question Bob asked, Arizona has chosen to trigger our election law and registration based on money and speech. Well, we don't have to do it that way. Federally, it's sometimes based on time. How far are you from an election? So we don't have to do it on money and speech. We choose to do that. It's a bad choice, in my view. I think we should move towards the federal system. But that is the type of debate we need to have to avoid some of the problems that Alan and Kurt are bringing up, to get to an election law that everybody can understand and not plow through a 187-word sentence.
I think you were next. I think you were the gentleman right here.
Do you think the CEO in California that lost his job when he sent money to a organization that backed, I think, Proposition 8, whether you agree with it or not, do you think that would be an example of someone who got ran over by not having dark money?
I think that's a good question for both sides. It's more of a challenge to the negative?
Sure, I'll take that. I mean, that's something I wouldn't, that's something a business community reacting to it would do. I mean, it's not something I would support someone doing. For instance, the owner of Chick-fil-A came out against same-sex marriage. And some people would boycott Chick-fil-A as a result of that. I don't know, I think they make a pretty good sandwich. And I
agree on something.
Well, and I choose to go there, even though I'm one of the lawyers who helped establish same-sex marriage in this state. So, I think people make their determinations. I mean, one of the reasons certainly corporations are in favor of dark money is they don't want to upset some of their customers. I mean, if you're Corporation X, you're going to have customers who are liberal, you're going to have customers who are conservative, and if you're making political contributions, you might upset one of those. I understand that. At the same time, I think that's outweighed by the public right to know, how these people are participating and to make whatever judgments they want to make based on that.
Does the affirmative want to take a whack at that one?
Sure. I think what that highlights, I think what you're talking about is the CEO of Mozilla, or the folks that have the search engine Firefox. Again, certainly wouldn't support what happened. I think that is a good example. But that highlights the issue to somebody who's not a CEO. The guy from Mozilla, I forget his name, I presume he's going to be all right that he lost his job. He I'm sure has worked his whole life, gotten there, is very successful. He loses that job, he's going to be fine. He's probably going to get hired as another CEO. But is it the same for the person who gives $100 to Planned Parenthood but works at a Catholic university or a Catholic hospital? They don't want their name disclosed because that's their job. That's how they put food on their table. And if they lose their job, unlike the CEO from Mozilla, that's going to be a problem. And so that's why anonymity is really a protection for what I'll call normal people, not CEOs, not millionaires.
We had another question, a hand up over here, and then we'll get to Roy. Is something already been asked? Roy?
I had a situation a few years ago where I wanted to I had an example a few years ago where I wanted to influence an election and was faced with overwhelming challenges in the law, not being a political action committee myself or a lawyer, and I really felt stifled in trying to get this done. And I want to ask a question going back to, I think it's Judge Teelberg's decision in the Fountain Hills case, and I would hope you would accept the premise that controls on contributions certainly stifle political speech in some way, and I sure felt stifled. And I'm wondering if that opinion essentially says, if you would agree, that if you want to stifle political speech, you got to be very, very particular and very careful about the definition. And I'm wondering if you'd agree with my characterization of the opinion and the substance of it.
Yeah, in terms of the district court opinion, I believe that it points out that Arizona election law is a complete mess. It is a complete mess. It is difficult for lawyers to navigate. It's very difficult. You know, I've known Roy for 40 years, and he's been in political things for 40 years. And if he has trouble navigating it, that just shows the mess it is. So what I think that opinion shows is that it needs to be cleaned up definitionally, and clearly the trend around the country, in the federal courts, is to be very suspicious of limits, $250, $500 contribution limits, and to allow relatively unfettered expenditures and contributions with instantaneous disclosure. And that becomes a simple system. And I think that's clearly the trend. And so, like the Arizona legislature has just finished a session where they maintained the $250 limit of the Fountain Hills case and maintained other limits. And it just screams for litigation. It screams for Alan to come from DC to Arizona and file another case like he has in Colorado. And instant disclosure with fewer limits will make it easier on everybody. And I think that's where the law is going with our current Supreme Court.
Tom and I were talking yesterday. I mean, we think the limits on contributions are just going to go away. And the whole distinction between contributions and expenditures is just going to vanish. And we're going to be, I mean, that's where disclosure becomes even more important. I mean, and the court has sort of signaled that. And I think we're going to go to a world where there are no limits and you're going to have immediate and fuller disclosure.
You guys want to whack at that?
I always enjoy these sort of lawyerly debates immensely, because at some point around the hour point, no one's had a snack and we start agreeing with each other. So I mean, I think you'll notice that there's a lot of agreement here. I mean, everyone agrees that trying to actually explain this system is impossible. I've tried to do it for hours to federal judges and had them still look at me confused. That's a problem. That's a problem for the little guy. That's a problem for the functioning democracy. Contribution limits, if they're too low, people are just going to try to find another complicated way to get involved. And that's where a lot of this problem comes from. A lot of this didn't exist when, you know, if you wanted to have a referendum on the Vietnam War and you didn't want to see a second President Johnson term, you had a guy, you could raise money from his rich buddies, everyone knew about it, he went in and he knocked the president out. And yeah, the disclosure is important. It is important in certain contexts. That contexts are where you've got an organization that exists to influence the election. But we're no longer having the dark money debate. Now we're just having the debate about how we actually structure campaign finance.
Question here? Wait for the mic if you would.
Thanks very much. Quick question, and it's kind of an interesting debate because dark money seems to be a term of art or a marketing term. It is
mostly the latter.
I'm sorry?
Mostly the latter.
Yeah, I mean, every day in my email, I get a fundraising email about stopping dark money in America from every Democratic congressperson I know. And that's fine, they can do that. Do what I do. But how is the way that, the dark money, one is, do you agree with that? And two is, how is dark money as it's perceived today any different than how unions have been funneling money into election cycles for the last 100 years through their nonprofit status? And isn't that what Citizens United based a lot of its and I'm not a lawyer, but isn't it based on a lot of that? I'll leave it to you guys.
Go ahead, Affirmative first.
To a point. I mean, first of all, if you'd like to just take over for me, like I think that was exactly right, in the sense that, you know, I hate this term dark money because I don't think it's intellectually honest. It's clearly a marketing term that someone came up with, and it's very attractive. I get that, but I think if nothing else, we've demonstrated this is a very complicated subject. And you know, whatever. If people want to raise funds off you by using the term dark money, and you don't feel used by that, that's your business. Sorry. But in terms of the Citizens United case, and it's funny that we've gotten this far with actually discussing it. No, it was not based principally on the way unions have been doing business for 100 years, although that's largely accurate. It was based instead on how the press has been doing business for 100 years. I mean, what were the facts of Citizens United? No one ever knows the answer to this question. Here are the facts of Citizens United. Okay, fine. A nonprofit organization wants to run a documentary film which is deeply, deeply pessimistic about a Hillary Clinton election and wants to run it during an election period. And at oral argument, you know, and this was going to be banned because corporate general treasury money was going to be used for this movie and its ads, which said very nice, not nice things about then Senator Clinton. And at oral argument, the Deputy Solicitor General of the United States was asked the question, well, okay, if we can ban the distribution of this documentary film that's not nice about Hillary Clinton, and we can do it within 60 days of an election over, you know, certain types of broadcast media, can we prohibit, I don't know, constitutionally the publication of books by corporations in the 60 days before an election that refer to a candidate? And everyone sort of freaks out because that's terrifying. But those were the facts. That's why it got reheard. I mean, Citizens United is not about dark money. It's not about any of this. It's about whether or not, you know, what the limits are on constitutional bans. And I think it's important, again, to remember when you're hearing all this highly rhetorical stuff, including from me, when you're hearing all this highly rhetorical stuff, that this is where it ends up. It doesn't end up it ends up being buried in a committee room somewhere in Congress or in a state capitol. It ends up with these highly complicated statutes that no one understands. It ends up in court, which unless you can hire, you know, one of us or Paul back there for free, is going to cost you money. And I think it's worth taking a pause and wondering if the sky is in fact falling over 5% of political spending.
You guys want to whack at that one?
Well,
Just a bunch of hype about nothing?
Yeah, very
let's all go home.
Yeah, very short answer on this. Citizens United, you know, did open the spigot for union and corporate funds, but as 7 justices of the Supreme Court said, that the campaign finance system paired corporate and union independent expenditures with effective disclosure. So that's what Citizens United did, because prior to Citizens United, well, everybody pushed the envelope. As Alan and Kirk said, everybody pushes the envelope, and they were pushed the envelope for union expenditures, for corporate expenditures, and it opened the spigot. But it was paired with disclosure, and that's where the statutes have to catch up, and to eliminate the cynicism in the system, we need to catch up.
We got time for one more audience question. Yes, sir.
Thank you. My question gets to the nucleus, I think, a little bit, being that if a public individual or private individual contributes, where is the basis as far as the Civil Rights Act, as far as being protected for wrongful termination? And also, can anyone answer if this anonymous money has influenced candidates' successful wins since it's begun in terms of...
Well, I think we have a few people here who have firsthand experience tonight in that. But as to your first question, I mean, if you get fired because of your political beliefs or something like that, you have recourse. you know, to bring a wrongful termination action, to do all sorts of things. I mean, there's plenty of legal protections for you under that. I mean, and that's one of the issues when they keep on bringing up this fear of retaliation. I mean, first of all, you know, you don't hear actual factual events of this happening, or you'll hear, you know, a few scattering things. If this was some massive problem, you would think that you would hear these problems all the time. I mean, I heard earlier this evening someone saying, you know, I don't want my children to have to deal with my $20 donation. Well, I'm sure my parents gave to all sorts of things. I have no idea what they gave to, and nobody has ever come and talked to me about it. And you know, just like most of us this evening who have given to various political causes, no one has ever approached you about that, except perhaps people of the same political persuasion. My God, I mean, when I make a donation to a Democratic candidate, Kirsten Sinema calls up immediately. I mean, I think she has like a drop phone. She uses different numbers. And I mean, you say, hey, I see you made a donation to so-and-so. Can you make a certain donation to me? I mean, that's the only harassment you get. So, I mean, I mean, this is something here where the fear of the boogeyman collides with reality. And the reality is that people simply don't get harassed for making political contributions.
So Alan, who are you contributing money to?
So yeah, or the reality is that people who are vulnerable are smart enough not to do things that'll get them hurt. I mean, so there's two problems. One is, yes, there are employer protections, and I'm not an employment lawyer, and I'm not giving anyone legal advice. But if you work for a Catholic hospital, you do not have protections for that sort of thing. I mean, this is a very hard-fought area of the law, but there are a lot of people employed in a lot of ways that do not enjoy those protections. And I would guess that a lot of them are smart enough to know that, one. And two, yes, my parents probably gave, well, my parents probably didn't because, you know, economics. But, you know, plenty of people did give to other things in prior days, and it wasn't online. So yes, okay, I'm sure you're going to get some information from somewhere, but that's comparing apples to oranges. And it comes back to this central problem that unless you have a time machine, the approach to threats, harassment, or reprisal that's being suggested here requires you to suffer the harm before you can get protected from the harm. And that's not good enough when we're talking about something as central as First Amendment rights.
And that's really not good enough, again, going back to the waitress or the person working in a mine in West Virginia. It's great, yeah, you have a legal protection. You've lost your job because you donated $100, or you wouldn't donate $100 to the candidate that your boss wanted you to donate to. So what do? You go to a lawyer. Lawyer says, you know, I used to do criminal defense in a previous life, and every one of my clients wanted to go to trial, and I said, that's fine. Yeah, we can go to trial. It's probably going to cost you $100,000. You're like, I'll take the plea, right? And it's the same thing here. Yeah, you have legal protections, but you have to go through that system. You have to go to a lawyer. You have to pay a lawyer. You have to navigate the civil law system for 2 or 3 years. But instead, what do? You do what Alan said. You just don't participate because you can't do that, because you have 2 kids at home and you want to go home to them and you want to make sure they go to school and they want to eat. So yeah, we don't have a ton of examples, but there are examples. There are examples. The one I just gave you is a real example of the harm that's done there. But why do we have to wait to suffer that harm under the Constitution to be protected from it? Just like Alan said, we shouldn't have to. That's what the Constitution's for. It's to protect you.
Okay, it's time to move to closing arguments, and the first closing argument will come from the negative side. You have 8 minutes.
Well, thank you, Bob. And again, thanks to the Goldwater Institute for hosting this. It's a very large crowd on a weeknight, and you know, we really appreciate the interest. On the 3 topics for tonight, in terms of, you know, is anonymity a First Amendment right? Well, I think we've demonstrated conclusively that it is not. 7-2, 8-1, United States Supreme Court, it is not a constitutional right to spend money anonymously. It's just not. And there's no way, nothing that's been said tonight changes that. And in fact, many people in this room have worked with Nick Dranius when he was with the Goldwater Institute. He's now moved on, but he is still publishing, and the Heartland Institute published a piece by Nick within the last couple of months decrying the present state of the law. In fact, Nick Dranius, citing to Justice Scalia and the Doe case and Citizens United, called the reasoning in those cases a bizarre line of analysis. Ironically, appears to originate from Justice Scalia, and says whatever the constitutional merits, that's the law. So he spends the next 25 pages talking about marching through legislatures, litigation strategies to get back to what he wishes the law was. There is no constitutional right to anonymous expenditures of money, dark money, for election purposes. That does not cross with newspapers, and as Nick points out in his piece. So I think that's beyond a refutation. And as Justice Scalia has said, and everybody else, that there is no right emanating from the framers, or at the time of the 14th Amendment's ratification, that there is a right to anonymous political speech. It's not there. So it is a matter of legislation. And we have states like Arizona with an election law that is almost incomprehensible, and that generates litigation, generates disputes when it doesn't have to. It's because of choices made by all of us, I guess, because we're not pushing the legislature correctly. There's some lesser controversies. There are many, many more bright lines in the federal law. Arizona law is fuzzy. Money and express advocacy. What could be fuzzier? Well, how much money? What's express advocacy? Federal level, so many days of an election. Here's what you can do, here's what you can't do. And that's what took Citizens United into court. Now, interestingly enough, Citizens United said, and it was addressed in Section 4 of the Citizens United opinion, that's a 7-2 section, said, well, we don't want to disclose because somebody might beat up on us. And Justice Kennedy pointed out that, well, you've always disclosed your donors for years, and you've had no problem. So for 60 years, we've had 2 cases that we've been able to identify where people were actually harassed. In those cases, the courts dealt with it. We have laws against harassment. We've got laws against intimidation. We can get injunctions for secrecy if it's warranted and if it's proven. It's worked. So going back to the question that Bob asked is, what about the right of the target? And that comes to the cynicism. We're the target. We're the target of the millions of dollars spent where we don't know where it's coming from. Well, don't we have the right? Well, some of you are old enough to remember the 1990s and remember the tort reform battles of the 1990s, that every election we had tort reform, and every election we had the Citizens for a Better Arizona vote no, and Citizens for an Even Better Arizona vote yes. And you would say, well, which one is the trial lawyers? And which one is the insurance company? Well, the legislature has passed for initiatives and referendums, you have to put on, right on everything, that who's your major donors? And so you could read on who your major donor is. Oh, State Farm, it must be the insurance guys. The trial lawyers, oh, it must be the trial lawyer guys. And it's easy to do. On issue advocacy in Arizona, we have that kind of disclosure where you know who's speaking. And disclosure, what does disclosure not do? It does not regulate speech. It does not. It just says disclose. And that's why the Supreme Court likes it, because it's a never-ending litigation saga to regulate speech. Not regulating speech by saying disclose, that goes to the core of Citizens United in 7-2 Section 4, where it says they're pairing corporate and union expenditures, open the spigot, pairing it with disclosure. And that gets to the cynicism angle. So the first 2 are easy. There's no constitutional right under the First Amendment for anonymity in political speech that relates to elections. And there's no going back to the framers to find that right. So number 3 is, what about the public? What about cynicism? What should we do to make our system as good as it can be? We need to clean up the laws, and we need to disclose. And with modern things, there's no reason that simultaneously, without you make a bank deposit, and boom, there's a disclosure at the Secretary of State. There's no reason that can't be done simply and easily. The Secretary of State software is pretty good, a little complicated, but pretty good now, but it can be done. And once we understand these constitutional rights or no constitutional rights, and we go to where Justice Scalia has gone, which is, yeah, there's no right to a secret ballot, but we have a right. Would we allow our legislature to go back to come in and raise your hand? Well, no, we wouldn't. But that doesn't create a new constitutional right. And there's no new constitutional right for secret tens of millions of dollars, because until January of 2010, in Arizona, it was a felony for a corporation to spend. It was a felony for a union to spend. And all of a sudden, one day in January of 2010, it wasn't anymore. So our laws need to catch up, so we have that disclosure paired with the limits being reasonable or non-existent, so that we can go forward and know who's talking, because that one or two people in 60 years is not many compared to the tens of millions of us who are voters who are the targets. Thanks.
Thank you very much. And closing argument, 8 minutes for the affirmative.
Thank you, Bob. I want to address a couple things. You know, years ago, it was a felony for an African American to ride in the front of a bus or use a white person's bathroom, too, until the Constitution said, no, it's not a felony, that's protected. The same thing here. I'm struck by the fact that Tom says that there is no constitutional right to anonymity, easy for me to say, in speech. After their opening statement, Mr. Barr indicated that he totally agreed that there was a constitutional right to speech. It was qualified in his opinion, but there's a right. So clearly there's even a disagreement on the negative side as to whether that right exists. I also appreciate continuous and repeated cites to Justice Scalia when he's in the dissent. Because when he says something in the dissent, that's not the law, and that's not the state of the Constitution. That's his opinion, but it's a dissenting opinion. The forced disclosure that we're talking about here really is a slippery slope. What it doesn't do, abolishing this anonymous speech, getting rid of it, what it doesn't do is what most campaign finance laws really are intended to do. And that's make the politician, the office holder, the people running and asking for your vote accountable. It does nothing to further that accountability. Even in the case of independent expenditures, where they're advocating the election or defeat of a candidate, they're not coordinating with that politician. They're not doing anything that could potentially, theoretically, cause corruption on that politician. Disclosing those names is really has no other reason other than to harass them, to expose them, to shame them. And again, I discussed earlier in regards to some of the questions that the current status of the federal law really means that those disclosures are made. Those big money, actually it's not even big money, over $200 to certain committees, you have to disclose. What we're talking about here and what we're talking about on the slippery slope really is going to go all the way down to C3s. That's the legislation that's being proposed here. C3s, nonprofits that cannot and are prohibited from advocating for candidates. Nonprofits like the Goldwater Institute, nonprofits like the ACLU or Planned Parenthood. The laws that are being proposed will force disclosure of those donors. Donors to organizations like Planned Parenthood. And it's those disclosures that will affect, as I've said over and over again, the smaller money people, the people that can't afford to be harassed, the people that can't afford to be exposed, that have a right to express their opinions in the way that they want and support the organizations that they want, whether they want to do it publicly or not. What we're really talking about when we talk about anonymity is really the marketplace of ideas. We want people to be, we want ideas, we want messages to be judged by folks based on the message, not by the speaker. I had to do this for my colleague Jim Manley, who gave me this today to bring. It's my only prop, it's all I got. The Federalist Papers, and we've discussed a little bit about this, but the Federalist Papers, on the bottom of this says Hamilton, Madison, and Jay. When they wrote them, it didn't say Hamilton and Madison and Jay, because what they wanted at that time was their ideas to be judged. They didn't want the person in Virginia to prejudge what the writer in New York or the Northeast was saying just because they were from the Northeast. They wanted to present the idea of a constitution, the idea that America was built around with, and have it judged and have it debated publicly, but anonymously, based on its content and not the speaker. It's really what we're talking about when we talk about forcing disclosure. We're talking about suppressing the participation. In today's day and age, there's too much risk to a person that they decide, I'm not going to participate. The big money people that we always hear names about, they are going to participate. The CEO from Mozilla, it's not going to hurt that person. But what it's going to do is it's going to suppress your voice, it's going to suppress my voice, and people like us. And this disclosure requirements or proposed disclosure requirements are going to go all the way down to nonprofits that are unable by law to advocate for the election or defeat of a candidate, but routinely advocate or promote ballot measures, discuss or weigh in and give opinions on legislation, and exercise non-election year advocacy over and over again. And it's those voices that could be diminished because people will no longer be comfortable to exercise their right. People will no longer want to donate to those types of organizations because of potential reprisal. We are never going to know how many people don't donate because of this fear. We'll never know that. We know about the NAACP and the horrific things, and we do know about the people who lose their job at restaurants or coal mines because of what they do. But we will never be able to quantify the people that choose not to participate because of that fear. And that's really what we're talking about here. We're talking about the participation in the disclosure requirements, forcing disclosure, and the abolition of anonymous speech will quiet speech and eventually eradicate the majority of it. And then our system will be run by the people who don't care, the people with all the money, the people that we talk about and demonize because they put all this money into elections. Anonymity protects everybody's participation, and that's what we need. Thanks for having us.
First of all, a big thank you to our debaters for sharing their time and expertise. Thanks to the Goldwater Institute for sponsoring this debate, and most of all, thanks to all of you for giving up some of your Tuesday evening to hear a real debate for a change. Thank you and good night.